Okay, now that we've talked about some of the founding principles behind the creation of the federal judiciary, we've talked about the lower federal courts, we've talked about the role of the president in nominating people to serve on the U.S. Supreme Court. Let's talk about some additional issues. We're going to talk about the role of the courts in a democracy, and then some of the elements of the court's decision-making process. Let's go. One way of talking about what role for the Supreme Court in a democracy is this. Some believe that the Supreme Court, the federal courts in general, should be activist, should be forward-leaning, should always be prepared to step in and limit the will of the majority in order to vindicate the rights and liberties of unpopular individuals and unpopular groups. So that, if you will, becomes a case for something called judicial activism, right? That the court is important to the democratic ethos, but it's particularly focused on that part of it that is all about rights and liberties. And as we've talked about, that's sometimes in conflict with the will of the majority. So that's one conception of what role for the courts. Check and balance on the will of the majority in order to vindicate fundamental rights and liberties. Judicial restraint would be a different emphasis, still recognizing the importance of the court's role in the democratic ethos, but focusing more on the idea of the will of the majority, popular sovereignty, that the court should be highly deferential to the will of the majority, partly because, hey, democracy is all about the will of the majority, and the court itself, of course, is unelected, not 9 unelected people. They should be deeply loath to challenge the will of the people unless there has been a very clear, very definite violation of the Constitution or federal law. So these are two basic ways of thinking about what role for the courts in a democracy. One more activist, one with the court being more passive, if you will, more restrained. And now some believe that political conservatives are advocates of judicial restraint and that liberals are advocates of judicial activism. I don't know about that. Couple problems with that sort of a connection. One is the fluidity of definitions, right? When is the court being activist? Many would say that the court was highly activist in Roe v. Wade when they took a very broad reading of the Bill of Rights in order to strike down laws that criminalized access to abortion in the case of Texas. There's a case for that. Now, what about some recent situations where the court ultimately decided not to strike down the Affordable Care Act, right? And in two cases, that's exactly what they did, where the court ruled a few years ago that the penalty for those who did not get health insurance would be treated as a form of tax policy, therefore well within congressional purview. And then, of course, more recently, where the court said that even though the language could be read otherwise, the intent of Congress was clear to provide federal subsidies for anybody who couldn't otherwise afford health insurance. In both cases, right, the court really deferred to the will of the majority. Now, where did liberals and conservatives come out on that, right? Liberals thought those were wonderful decisions. They said, fantastic, the court has refused to overturn the will of the majority. We think that's exactly right. And what did conservatives want out of that? They wanted, if you will, some form of judicial activism, the court whacking away at decisions arrived at by Congress. Both of those decisions are eminently defensible, but you can see the inconsistency here, right? Where you could argue that conservatives are arguing for a form of activism, liberals arguing for a form of restraint. So often it just matters so much. Do you like the law in question? If you like it, you want the court to be restrained. If you don't like it, you want the court to be activist. But that's really less about what you think about the role of the court in a democracy, more about how you feel about the underlying law. So that kind of misses the mark here, right? We should also note that what is activism exactly? You know, because the conservatives would say, hey, Carlton, we're not in favor of judicial activism in those cases. We just want the court to do its job. Congress clearly went beyond some of its Article 1 powers when they passed the Affordable Care Act, and they used language that seems to suggest that you deny federal subsidies to some and not to others, depending on what state you live in. They screwed it up. Too damn bad for them. The court is merely holding Congress to its word. Right? So they would say that's not activism. We're not favoring activism. We're favoring the court doing its job. But that's the problem, right? What's activism versus what's the court doing its job? It's how you feel about the underlying law, right? Because liberals could say the same damn thing about Roe v. Wade. That's not activism. That's the court doing its job. It's the court establishing a zone of privacy that is clearly endorsed by the thrust of the Bill of Rights, and including within that a key liberty, the liberty of women to control their own bodies vis-a-vis the reproductive process. So liberals would come right back and say, again, we're not in favor of judicial activism in the case of Roe v. Wade. We're in favor of the court doing its job. So that becomes another difficulty, right? The fluidity of the definitions. Because almost nobody will actually defend activism. They'll just say, hey, I just want the court to do its damn job. Opponents will call it activism. So that's a real difficulty with that whole debate of activism versus restraint. Everybody says they're a restrainist, but the court should sometimes step up and do its job. If you like the job that the court has done in overturning the will of the majority, you'll call it the court doing its job. And if you don't like it, you'll call it activism. And then the ideological labels switch back and forth depending on the law in question. If it's a conservative law and you want to uphold it, you're probably going to argue that this is restraint. If it's a liberal law and you're a conservative, you'll argue that it should be overturned by the court. That's the court doing its job, not activism. These are some difficulties, very real difficulties with using these definitions in a partisan way. The sheer fluidity of what these terms mean and how they're understood varies so much by ideology. Another problem with saying conservatives favor restraint, liberals favor activism is historical inconsistencies. What did the Supreme Court do back in the early years of the New Deal? They struck down a lot of New Deal legislation. What kind of justices were these? These were conservative justices put there by presidents like Herbert Hoover, Calvin Coolidge, and so forth. What's that an example of? A deeply conservative court being very activist, you could argue, in striking down New Deal legislation that they believe to be unconstitutional. And what were liberals arguing for? Judicial restraint, right? Leave those laws alone. Defer to the will of the majority. And these were liberals advocating, if you will, a form of judicial restraint. So again, so much of this is about how do you feel about the underlying policy, and then the sheer fluidity of the terms activism and restraint. So at some level, if you try to make these partisan terms, it breaks down super quickly and becomes dysfunctional, unuseful, and so forth. Is unuseful even a word? I don't know. If it isn't, it probably should be. So where does that leave us? I still think thinking about it in those terms, as long as you don't try to connect it to politics in partisan fashion, I still think it's a useful way of thinking about very broadly what role for the courts in a democracy, right? I mean, and in the abstract, how do you feel about what role for the courts? Should they be more involved in policy making because they're there to defend the rights and liberties of the unpopular, of the marginal? Should they be there in part to defy the will of the majority? In some ways, that's what the founders did want, right? Because they were skeptical in some ways of the will of the majority. Or, just as legitimately, should the court be more restrained and very passive? Hey, they are unelected. There's only 9 of them. And on the current court, right, you would say it's not even 9 so much as 1, because you have 4 reliable liberals, 4 reliable conservatives. Anthony Kennedy is the man in the middle. And so in a very real sense, when you give the court a lot of power, you're giving an awful lot of power to Anthony Kennedy. Cool if you're Anthony Kennedy, but maybe not as cool if you're not Anthony Kennedy. And most of us are not Anthony Kennedy. So that becomes an argument, right, that, hey, why are we putting so much power in the hands of one person who's unelected? The court should be more passive, should be more deferential to the will of the majority. So in that sense, I think the terms activism and restraint are useful for thinking in the abstract about what role for the courts in a democracy. But very quickly, if you try to transfer that to contemporary politics, partisan questions. It breaks down in the ways that I think I've suggested. Hopefully I've been persuasive. All right, let's move right along here. Next, I would like to talk a little bit about how the Supreme Court decides in a couple different arenas here. First of all, to note something that may be terribly obvious, how the court decides cases is often intensely political. As I've suggested, in a lot of these hot button cases, you end up with 5-4 or 6-3. So let's be very clear about that. I mean, look, the court is unanimous about half the time. Typically, these are going to be on low intensity cases that involve fairly technical issues where you can find agreement across ideology. And that's certainly a good chunk of the court's caseload. And you don't hear about those cases because those are only important to a small segment of society who care about these very narrow, often very technical issues. But the big ones, right? The ones about voting rights, the ones about affirmative action, the ones about same-sex marriage, the ones about the Affordable Care Act, the ones about prayer and in public schools. All of these much more likely to be 5-4, 6-3. That's when a justice's true ideological colors come out. And I would argue nothing wrong with that. It's the nature of the beast. Completely unavoidable. Always has been, always will be, I would suggest. And before we get into some of these theories of how the court decides cases, although I'm going to often suggest that the bottom line is it's their politics that matter, let's first talk about how the court decides what to decide. In any given year, the court is presented with as many as roughly 10,000 petitions. They obviously cannot hear 10,000 cases. That would be foolishness. They typically hear fewer than 100. I think at one point they were up to about 150. These days, I think closer to about half that. So maybe 75, 80, 90, something like that. So there's a tremendous funnel effect. Many are called, few are chosen. How can we figure out what's going on there between 10,000 coming in and a drip of about 100 coming out? Well, there's something called Q theory. And Q theory says, look, there are three major factors to look at here in figuring out how the court is making these cuts. Well, first of all, some of that's being done by their staffers, right? Each justice has a staff. Some have called the Supreme Court a loose collection of 9 different law offices. So they each have their own staffers. These are typically high-end lawyers from Ivy League schools, very accomplished lawyers themselves who do a lot of this winnowing through the 10,000 appeals for ones that are more likely. And they'll typically summarize each case with one page and suggest to their boss which ones are more likely and which ones are pretty ridiculous. A lot of them are very ridiculous. So Q theory, factor number 1, is there conflict among the lower federal courts over some provision of the Constitution or some provision of federal law? If there is, right, that's a problem. The 14th Amendment cannot mean one thing in one jurisdiction and another thing in another jurisdiction, but that does happen. On affirmative action, at one point, you had the Fifth Circuit holding that race-based affirmative action was always unconstitutional, a case called Hopwood v. Texas, but all the other federal circuit courts said that indeed not necessarily, and it depended, and you use strict scrutiny, and blah, 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 right? So the 14th Amendment meant one thing in the Fifth Circuit, another thing in all the other circuits. More recently on same-sex marriage, the Sixth Circuit said that in their view, the Supreme Court had not yet decided, and that the 14th Amendment did permit states to ban same-sex marriage. All the other circuits that ruled on it went the other direction. Unacceptable to the Supreme Court, right? We can only have one Constitution, one federal law. And there used to be disputes over Title VII of the Civil Rights Act of '64, what constituted sex discrimination. Some lower federal courts were saying sexual harassment was a form of sex discrimination. Others were saying it was not. The court had to hear that in a case called Meritor v. Vincent, and they said that indeed it was, could be. So conflict among the lower federal courts, the court is highly likely to hear that kind of a case. Issue saliency, Q theory, issue number 2, issue saliency. It's just like Congress or the president or a state legislature. Is it an issue people care about? Has it risen to the top of the political agenda? Some have said the Supreme Court follows the election returns. There's truth to that. They are insulated from direct popular pressure, but they live in the world, right? They're citizens just like the rest of us. They pay attention to the news. They're interested in the kinds of issues that we're interested in. So if an issue becomes very salient, like same-sex marriage, they're likely to hear it. If it involves the Affordable Care Act, pretty likely to hear it. People care about this. If it's a presidential election, like in 2000, that's pretty salient to the American people and to the Supreme Court. So issue saliency definitely matters, and those issues vary over time, right? We've seen that for well over 100 years, the court really didn't hear any First Amendment cases dealing with free speech. But beginning in the early 20th century, free speech became much more salient and significant. The court paid a lot more attention to it. Same thing with abortion and so forth. All right, so issue saliency. Factor number 3, is the U.S. government party to a case? You look at any con law textbook and you'll see that a lot of the cases are U.S. v. Virginia or something v. U.S., U.S. v. You see an awful lot of that. So when the U.S. federal government is the party to a case, the Supreme Court is much more likely to hear it. The data I've seen suggest that when the U.S. government is a direct party to a case, the court will hear those cases about 2/3 of the time. Right, the success rate for other cases has to be way below 1%. If it's 10,000 cases come before them, they actually hear about 100. That's a hit rate of about 1%. But when the U.S. government is party to a case, the hit rate is about 67%, 2/3. So that's a major cue. U.S. government party to a case, or for that matter, the U.S. government has filed an amicus curiae brief in a case where they're not one of the two parties, but they are interested in the outcome, so they will often file a legal brief with the court saying, look, we're not involved in this case directly, but we sure do have a stake in the outcome, and this is the position that we take. Those are also cases where the court is highly likely to hear that case. And by the way, typically when the government is party to a case, that they win about 2/3 of the time when the court does hear their cases. So those are some preliminary issues that I want to talk about regarding the Supreme Court and its decision-making process. I think we're going to end this part of the court material, and I'll mount some additional slides here under part 3, dealing with questions such as, in terms of when the court is looking at a case, do they use strict constructionism and original intent? Do they use judicial interpretivism and Constitution as living document? We'll talk about all of that in part 3 of the court.